I'll frame this with a Wall Street Journal story in September 22. Adobe agreed to buy collaboration software company Figma for around $20 billion, using the biggest deal in its history to acquire a small but fast-growing rival that the tech giant hopes can give it access to a broader group of customers. The smaller company was valued at $10 billion in a funding round in 2021 and has been expected to surpass annual recurring revenue of $400 million for 2022, about 1/50th of its sale price. Adobe said Figma has gross profit margins of approximately 90% and positive operating cash flow. And then fast forward to this week.
By the way, just one bit on this, because a lot of that purchase price included stock, and Adobe's stock is up, so it's actually more like $26 billion in today's dollars.
Condolences to any Figma employees who are listening to this podcast. Continuing to this week from The Verge, they write, following mounting pressure from regulators in the UK and EU, Adobe and Figma announced on Monday that both companies are mutually terminating their merger agreement, which would have seen Adobe acquire the Figma product design platform for $20 billion. As a result of the termination, Adobe will be required to pay Figma a reverse termination fee of $1 billion in cash. Regulators cited Adobe's near monopoly in the design software market as they pushed back on the deal. By purchasing Figma, a fast-growing product design platform that's now more popular than Adobe's rival XD application, regulators worried that Adobe would harm innovation that could have occurred should Figma be allowed to flourish independently. Designers have expressed similar worries since the merger was announced in September 2022, but Adobe pushed back on those claims throughout the various ongoing probes. So, Ben, a lot of directions we can take this. First and foremost, what do you think of a bunch of European regulators poking around our companies, telling us what two California companies can and can't do?
Well, I mean, I have a few bones to pick with the regulators. I think this is a big problem systemically, particularly like Europe has decided like our innovative contribution to technology is regulation. It's like it is a fundamental
the last
issue.
Card they have to play.
Well, I mean, like, for example, there's this AI regulation sort of, that's framework that's been agreed to in the European Parliament, European Commission. We'll see what happens with it. France in particular, speaking of France, is pushing back pretty hard against it in certain aspects of it. Why? Because Mistral is like one of the leading open source AI companies, and it's a French company. And that's fine. That's healthy, right? That's what you want. You want various stakeholders going back and forth and getting to sort of the right place. One of the fundamental issues, big picture, when it comes to the European Union's sort of role in tech is you don't have countervailing sort of incentives, right? In the US, there's obviously the U.S. cares about tech companies. It cares about their profitability. It cares about their power. It cares about their capability because it accrues to the benefit of the U.S. Right. And obviously the U.S. has to also consider the consumers, the end users, and have the appropriate regulations and those sorts of things. And that's healthy. That's sort of a good dynamic. This situation we're in, where Europe has no tech industry to speak of, but they have plenty of regulators, is a big problem. And it is bad for consumers. Like, who here likes to click the cookie banner on every single page, or 47 gazillion things, or do that's the easiest one to pick on, but the reason it's so easy to pick on is because it's so
self-evidently stupid, and it's something that we're all just going to be living with maybe for the rest of our lives. I don't see anyone in the EU repealing any of the regulation that doesn't work, which, by the way, is an important concern. It's never rolled back, and so it's fair to push back against it as it's rolled out, because it never goes the other direction.
Right, and this is a bit of humility that I think the pro-regulation set needs to keep in mind. It's good it's hard to pass regulation in the U.S. It's good it takes a long time, because there are massive long-term costs. If you get stuff wrong, there's always unintended consequences. There's deadweight loss, and you're stuck with it. Stuff doesn't, there's a one-way ratchet. And so we have this sort of entity broadly, speaking of Europe as a whole, that is cranking this one-way ratchet with no pushback, and we're all left to deal with it. It's it's not great. It's definitely, and they don't care what happens to innovation in America. They don't. And yeah, so I do have a problem with the big regulators. Number one, in Europe,
Yeah.
and number two, I thought the way they handled this deal was really annoying. Like, they just waited till the very end to even start considering it, and then they asked for all these documents and they pushed it forward. And at some point, like, you put an 18-month sort of window on closing a deal. That should be enough time. And you were seeing this happen again and again. The FTC pulled the same BS with Activision, where they, like, waiting until the very end to sort of like, fortunately, they got the court case in time and sort of it happened. I say fortunately from just a process perspective. Look, merger should be reviewed. We'll get to the details of this one in a moment. But I think that I'm not sure how to fix it, but I think it behooves regulators to act more quickly in this case. Let's at least resolve it. Whatever way it gets resolved, let's resolve it more quickly. And in this case, we didn't even get to a review because the clock ran out. And so just because
that's the thing. Yeah, I mean, I think the structural questions that this highlights are questions that we've encountered elsewhere, including with the Activision deal, where the UK nearly held up that merger. And it just highlights this sort of difference in law that is going to continue to be a real problem for companies around the world, and primarily U.S. companies that are doing business around the world, whether it's mergers that are held up by China or the EU or the UK. And we've talked a lot about what an interesting time it is for antitrust and big tech on this podcast. And I think those questions should be answered in court and in Congress over the next 10 years. But it also seems like a lot of these cases are going to be decided by like disinterested parties in the EU going forward. And that's
not just that, but they weren't even decided. It was just slow rolled until it was killed, right?
Right, until these guys had to kill the deal, and then there's no real right to review. There's no precedent. There's
no standard that's laid down. Like what is, like, if this was actually reviewed and it was actually banned, they would have to issue an opinion. They'd have to explain what was the issue here, which would actually give guidance to future companies, even if we're going to have this crazy structure where not improperly incentivized regulators in the EU get to rule on U.S. tech acquisitions. At least you would know the lay of the land. But this is an issue with EU regulation in general, is they just sort of issue these vague things. You have to do this. There's no actual guidance on how to do it. You try to implement it, and they're like, nope, that's not right. Do it again. And it's like it's such a staggeringly business unfriendly sort of case. This should be part of your French sort of business sort of consideration. Like, you need
this is how you lose out.
Even if the rules are crappy, if you at least know what they are, you can work around them. But the EU doesn't even grant you that.